May I begin?
Yes.
Good morning, and may it please the court. I'm Julia Schroers, representing the Board of Education on this case. I want to briefly remind everyone exactly of who Kim Park is. She is an upstanding member of her community. She's an exceptionally hardworking student, the daughter of immigrants excelling in a male-dominated extracurricular. As a result of the events that transpired, she was led to attempt suicide. She had to spend the rest of her senior year in intensive counseling. She could not finish, as we don't know in the record, but she presumably had trouble finishing high school and certainly did not graduate valedictorian. These events absolutely ruined her.
But does it matter, do we judge this by a subjective standard or an objective standard? Meaning, is it the impact to Kim herself, or do we look at what a reasonable person would have done in response to the bullying?
I think that,
what is called bullying?
Thank you. I think that under both metrics, you should uphold this particular, the decision of the lower courts. Firstly, because there is legal precedent to value the impact on the victim, no matter what the victim felt, whether we judge that to be reasonable or not, that there is precedent for that. Doe Blogs was a case where there was serious consideration taken into how the victim reacted to the events, but there is also precedent just for what ended up happening. We think it is reasonable that under the immense strain that Kim was placed, with consideration for the fact that she was a high-achieving high school student, that she was placed under public vitriol, that she was humiliated in front of her community, that this was a reasonable reaction. Being sent a message by your peers in high school that somebody wanted you dead is a reasonable reaction. And the impact that it had on her as a student was reasonable, and it was severe, and it caused disruption to her ability to participate in school.
Excuse me, Counselor, are we talking strictly about the text message now?
Yes, good question. So the text message is the consideration for the bullying, right. But we think the Board of Education thinks, considering the context that she was under, this message was not sent in a vacuum. It was sent with the context that she was that by word of mouth, her peers were shaming her, and by public social platform. That's context.
How did the private text get beyond Ms. Parks? How did other people learn about the text?
Other people learned about the text after she attempted suicide and after the investigation from the school board ended up happening.
Okay.
Thank you. So, Tinker v. Des Moines establishes precedent that schools may interfere with speech and regulate speech if it causes a substantial disruption to the student's ability to participate in school. Doe Blogs v. Hopkinson from the U.S. Court of Appeals establishes precedent that courts generally defer to schools' administrators' decisions regarding student speech. The School Conduct Committee voted to expel Theo. The lower court upheld this decision on the basis that it was legal. The Board of Education urges the judges to consider the decision that was not only made from the lower court, but by the community that was affected by this very issue.
Is there any limit on the school's reach if two students are on a ski trip in Colorado and they start, makes these types of comments to another, say, and it's not a school trip, it's just a private trip that they're out there, and one says to the other, I wish you would die. Can the school reach that?
If it impacts the school and the ability for students to function in school, yes, they can. But it's also too important to consider that this did happen on the day before school, during the school year, in front of the very students that were affected by it. That's an important consideration in the case that is before you.
Did it happen, you said during the school year, did it happen during the school day?
It happened the night before, so.
So no, did it happen while they were at school?
No, it did not.
Okay, so but to Judge Bragg's question, don't we have to be a little bit concerned about the extent to which we interpret these types of communications as being disruptive to the school environment? And at what point do we become concerned about protecting the First Amendment rights of people to freely express, to free expression, excuse me?
Yes, we should be very concerned about that, but the argument that is being put forth by the Board of Education is that this was something that impacted the school. Would you mind repeating the question?
I think you answered the question, actually.
Wonderful.
Yeah.
Yeah, the First Amendment is an important consideration, but it is under legal precedent from the Supreme Court, from the state Supreme Court, that there are exceptions to that. This caused a student, a high-achieving, successful student, to be brought to the point of attempted suicide. That is a disruption to the school environment. It is a disruption to the student. This makes this speech an exception to the First Amendment. All right, so the premise of the Board of Education's arguments are to prove that this caused harm, that this was, as our opponents, as our esteemed colleagues had brought up, that this was, that this did quantify as bullying under both the state and the school statute, and thus should be evaluated as a violation of the bullying policy. One of the considerations that has to be required is, did this constitute a form of prejudice? And under both the state and the school statute, it did, on two accounts. Firstly, on the account of racial discrimination. Once again, it's important to consider the context through which this message was delivered. The entire premise of the events that transpired came as a result of this student being of Asian American descent, of being accused of not deserving an award on that basis, and of winning an award on that basis. The message delivered was one that said that she stole an award from Bobby and that she didn't deserve to even be at the school. The implication is on the basis of race. She didn't even deserve to receive the award in the first place. But secondly, on the consideration of academic status, which is a characteristic that the state statute defines as a characteristic that cannot be targeted without violating the bullying policy, the entire events that transpired came as a result of this student receiving an academic award. Every single form of vitriol that came at her was as a result of this. The text message itself calls her a witless runt. It says that she doesn't deserve it to be at school. All of these things are on...
So are you saying that, when I think of academic status, meaning that you can't discriminate against someone because they're not performing well, are you saying that that also means that if you're performing really well, you can't be discriminated on that basis?
On both counts, yes, that is a consideration. The state statute says that any academic status...
Finish.
Okay, but secondly, that he is also saying in his message that she is unintelligent, that she didn't deserve the award, that she's a witless runt. The implication is both that she shouldn't have won it in the very first place. We urge you to uphold.
Okay, thank you. All right, so now we'll hear the cross appeal, and we'll hear first from the cross appellant, Attorney Colombo. Ready to go? Okay. Yep.
All right, may I begin, please?
Yes.
Good morning, and may it please the court. My name is Marcus Palumbo, and I'm here today on behalf of the Town of Nutmeg School Board. I will be addressing the issue of whether or not Theo Jones's Facebook post constituted a true threat. I'll first begin by giving a brief overview of the true threats doctrine as it stands today, and then I'll present two reasons for why this court must reverse the lower court's ruling that the true threats doctrine didn't apply to Theo Jones' Facebook post. So, the First Amendment enshrines the right to freedom of speech. However, to quote the opinion of Chaplinsky versus New Hampshire, quote, there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional concerns. Now, since Chaplinsky, the Supreme Court has outlined several classes of speech outside of the First Amendment protections, and one of those are true threats. Now, the true threats doctrine itself was established over 50 years ago through the Supreme Court case Watts versus United States, which held that the context in which a statement was made and the reaction of listeners were important in determining if something constituted a true threat. And Virginia versus Black, another Supreme Court case, elaborated on this by holding that, quote, the speaker need not actually intend to carry out the threat, end quote, because the true threats doctrine exists to protect individuals from the fear of violence being done against them. And more recently, lower courts have attempted to set even more specific definitions of a true threat. The Connecticut Supreme Court, in Hogwatt versus Tordini, held that in order for a statement to be a true threat, quote, a reasonable listener, familiar with the entire factual context of the defendant's statements, would be highly likely to interpret them as communicating a genuine threat of violence. So with that, what are the reasons that the lower court erred in holding that the message did not constitute a true threat? The first way the lower court erred was failing to consider the implicit meaning of the language used. So on its surface, the statement that you're going to, quote, fire someone does sound innocent. I mean, terminating someone's employment is something that is legal in many cases. However, this message takes on a darker turn when the person sending it has no ability to actually fire those committee members. Now, since Theo Jones can't literally mean fire, then he must be implying something. Now, one likely interpretation is that the comment alluded to arson, because in the comment he followed the word fire with several flame emojis. Another possible interpretation is that the speaker was referencing a gun, because the discharging of a gun is often referred to as firing. And this is certainly a reasonable.
How is that last interpretation consistent with the fire emojis?
Because firing, whenever you refer to discharging a gun, you would call it firing the gun.
Yeah, but then you have the fire emojis afterwards, which support your first interpretation, but they seem inconsistent with the firing the gun interpretation.
Correct. Yeah, there is some discrepancy between the two, but the main takeaway.
What was the board's conclusion as to the meaning?
The board's conclusion is that the arson comment is probably the most likely, but I want to emphasize that regardless of whether the comment was referencing one interpretation or another interpretation, the clear takeaway is that the implied meaning was not to literally fire the person, but it was probably to do something illegal. And so the ambiguity of the statement actually makes it more frightening, because the recipient of the threat wouldn't know what form a possible attack, violent action against them might come from. And humans do have a well-documented fear of the unknown, and this statement played right into that fear by being ever so slightly vague. In fact,
So why wouldn't it be just as reasonable for one to presume that he was being facetious and that if he had the power to fire them, he would? I mean, and as to your question about your point about the unknown being more scary, I mean, wouldn't it be more scary if he said, I'll be burning down your homes tonight? That's something that would have been known. Would that have been more scary?
So the board actually contends that the ambiguity makes it more scary because you don't know how to protect yourself. So if in that scenario, let's say someone did threaten specifically to burn down your home, you know exactly what form the threat's coming. You could even take action to try to protect against it. You could, have people on watch, right, to make sure your house doesn't get burned down. But because you're not clear which form the threat's coming, it means that you don't have any ability to, protect yourself.
You're not suggesting that his speech would have been protected if he said, I'm going to burn down all your homes?
No. And actually, I want to add on to that, to point you towards the Connecticut Supreme Court, in the same case I mentioned earlier, held that a rigid adherence to the literal meaning of communication, without regard to its reasonable connotation, would actually basically render statutes that prescribe true threats powerless, because, in other words, even a veiled statement could function as a true threat. And if we only look at the literal meaning, we allow threateners to get away with making threats just vague enough to avoid being punished, but still specific enough to cause fear. And I think that's exactly what happened in this case. I think it created that same fear, not just in spite of its vagueness, but because of it.
What evidence is there that he created fear among the members?
Well, unfortunately, the stipulated facts do not have any testimony from any of the committee members. However, one thing we think might actually be indicative of the fact that that they were afraid was that they did choose to take action on figuring out who sent it, right? So they were concerned enough about this to want to uncover who was behind it.
May they just been concerned because they felt embarrassed and they were going to ferret out whoever it was that was embarrassing them, punish them?
I think that the interpretation of the actions of those committee members is we obviously can surmise what they may have done or why they did it. And I don't know that we can actually draw any conclusion from that. I think that we have to interpret, in this case, because of the limited evidence, we have to look more at the statement itself and the context in which it was made, because unfortunately we don't have any testimony from any of the listeners. And just briefly, to get into the second reason, because I think it's somewhat connected, I think the second reason that the lower court ruling should be reversed is because the lower court failed to take into account the anonymous nature of the comments that were made. So when the committee members read that message, they didn't know anything about the person behind it. They didn't know their identity, their age, whether they had a history of violence. For all we knew, they could have been some disgruntled parent, right, who had access to a gun. We don't know that this was a kid. And so that means that the people who viewed this message didn't have any way of evaluating whether or not it was a credible threat.
But they did when they made the disciplinary decision. They knew who they were disciplining at the time. And so when they made the decision, which is at issue here, isn't that what's important to determine whether this was by them considered to be a true threat that justified punishment?
Your Honor, so can I finish? Yeah. The comment itself was posted on Sunday night, And the identity of the individual behind it was not uncovered until at least Wednesday. And so our argument is basically that in the interim, that time when no one knew who was behind it, that the anonymity gave greater fear, caused greater fear because the people who it was targeting were not able to know who was behind it and whether or not they were serious. Thank you.
Thank you. I'm always amazed at how well prepared the students are and how well you do. And I would like to have some of the attorneys come in and watch you sometime to see how well maybe learn from you. So I hope you all continue to pursue this line, and maybe we'll see you back here someday arguing before us again.